of Lipton.
Thank you, Mr. Speaker. Like some of the previous speakers before I rise in opposition to this bill, and I'd like to expand on some of the remarks that I made yesterday. I took the time to reread a document that I think at least many of the people that were here last term are familiar with, and that is the Judicial Crossroads Task Force report that took a very, very close look at judicial reorganization resources and has guided us in terms of how our court system can be better improved. And I took the time to re-review it, and it's interesting that there's actually only one mention of the Court of Claims in the entire Judicial Crossroads Task Force, and that is to expand the Court of Claims in matters of tax tribunals. And it got me thinking that if such a document that's taken a comprehensive look at our judicial system in this state saw a fundamental problem with something as serious as some of our colleagues are talking about, I think that they would have mentioned it in this report, and its absence, I think, is extremely notable. I think that that should at least guide us in terms of whether there is in fact a problem at all that needs to be fixed. Of course, we know that that's not the case. This is a solution in search of a problem. There is no problem, of course, with the Court of Claims. And as one of the few members in this body that actually practiced as a trial attorney for nearly 20 years in both the state, federal, and appellate courts in the state, I can tell you that the notion of actually having our Court of Appeals function as a trier of fact is actually preposterous. I mean, think about it. It's absolutely fundamentally preposterous. The fact that we would actually have those that are skilled at reviewing cases that are on their briefs, so to speak, the fact that they would actually function and that we would expect them to function as the trier of fact is nothing short of ludicrous from the standpoint of those of us, albeit few, I will say, who have actually practiced rigorously in the trial courts of this state. The thing that I think is most concerning about this is the fact that we are talking about fundamentally changing the system of justice for those that are desperately trying to litigate their cases fundamentally about the unchecked power of the state. And I know that there are people in this body who are very concerned about the unchecked power of the state. And let me give you some examples about why we should be very concerned. We have statutes that deal with the Open Meetings Act. We have statutes that deal with the Freedom of Information Act. We have statutes dealing with the Persons with Disabilities, Civil Rights Act. And this legislation, most disturbingly, eliminates the right to jury trials in many of these cases. And you have to ask yourself, why would we possibly want to do that when we all know that the right to a jury trial, the right to a jury of our peers to hear cases involving the unchecked power of the state, that is the cornerstone of the democratic process. That is what caused this country to stand apart from those that were being hauled in front of the Star Chamber. That is what this country did differently. And the fact that we would be taking this action here today to turn that on its head it confounds logic. Lastly, I would like to just read a few comments from attorneys that have labeled this is a very dangerous bill. This eliminates the right to a jury trial. It promotes secrecy in government and shields the state from FOIA and Open Meetings Act cases. And finally, we should remember the language that Bruce Timmons, a longtime member of the staff and someone that I trust implicitly in matters of the judiciary, said, and it was so profound that I wrote it down when he said it, he said, "This bill should die." I think those are very, very powerful words from someone that we should all open our ears and listen to. And on that basis, I strongly encourage a no vote on this bill. Thank you.
Thank you, Representative.